So, Richard, I really like the paper. There's a lot that I agree with here, even though you and I probably start from slightly different starting positions here. So, I believe that the object of constitutional and statutory texts should be the authorally intended meaning, the meaning the authors intend for that text. So I'm in that camp of originalists, that small camp with people like Rick Kay, Cy Prakash, Stanley Fish, Walter Ben Michaels. We're outnumbered by the original public meaning folks, but that doesn't deter us. So we, like you, reject the original public meaning approach. We say the reasonable audience of the original public meaning approach is after the authority intended meaning, and that the authors themselves intend their intended meaning is the uptake that they expect of their audience. So I'm with you in rejecting the original public meaning approach to the extent it differs from authority intended meaning. I'm not sure how much it differs, but it does differ conceptually. But the authority intended meaning approach has to overcome the multi-member authorship problem and the possibility that no meaning was intended by a sufficient number of authors. And I don't think the solutions offered by Scott Soames work. I've told him that. Same thing's true with the solution offered by Richard Eakins. I don't think that works. So the result, I think, is that to the extent we move beyond what there was a consensus among the authors in terms of their intended meaning, the marks on the page become an ink blot. But at this juncture, I think as I read your paper, you and I part ways. You would have the judges, when they confront the ink blot, give it the best moral reading as they see it. In other words, you favor a constitutional juristocracy in which, in the name of the Constitution, the supreme law of the land, you're willing to give the ink blot what the judges think is the best moral case. I tremble at the thought of what the Supreme Court confirmation hearings are going to look like if that were really the case. I would prefer something different, which is when it's an ink blot, there's no constitutional impediment to the democratic procedures, so the people can decide whatever they want to, and so I would like to know why you think giving the judges that power is better than letting the people decide.
Okay, Chris.
Okay, so I'm really going to try to be as quick as I can. Huge fan as well of the sentence on page 8. Constitutional truth maker. That's a nice phrase you might use at that point. My second favorite sentence was on page 45, and it's related. The legal and moral legitimacy of the framers and ratifiers in establishing the Constitution as law is perhaps the deepest implicit assumption of American constitutional practice. You want to be really, really careful how you word that, because I'm fixing to quote that. And I think the next question you get after that, though, should be, what is the Constitution? What are we talking about? So Tarski, his stuff on truth, we have a term. What is it trying to refer to? What is the thing about which we would have to be ignorant if we are ignorant of constitutional requirements? But it seems like that's a problem for anybody, originalist or just anybody needs to say, like, what is this Constitution that we're talking about? What renders these claims true or false? 14th Amendment stuff seemed a little thin. It just didn't seem to really do anything to push back against the claims that the Equal Protection Clause is a duty to protect rather than a general requirement of equality. So to the extent that you're going to really claim, you know, Evan has not proved his case, I haven't proved my case on a similar paper, you need a lot more than just pointing to school segregation or women's right to practice law. I mean, the answers to those questions are just easily no. Right to practice law is not included in protection laws. Right to go to school is in protection laws. Those are difficult questions under the Privileges or Immunities Clause, but not under equal protection. And then finally, I wanted to give you a major kudos for your footnote 31 on noting epistemic ontological distinctions. I feel like the whole thrust of the paper, though, is resting on not distinguishing those sufficiently clearly. So Michael Devitt's work, I think, is great. I'll hold up this wonderful book, which I was provoked to read because of your footnote 31. So Michael Devitt he argues that competent language users frequently don't know the rules of their own language. He talks a lot about Carl von Frisch's work with bees. So bees do not know their language, but they use it competently to communicate which direction you have to go relative to where the sun is. We have these order of adjective rules. We know we talk about big red balls instead of red big balls. We're like, what? You know, because we just know that certain adjectives go before certain other adjectives, even though we've never articulated it. Devitt's stuff about the possible existence of a linguistic convention that we just don't articulate, I think is very powerful. David Lewis's stuff on convention, I think, really gives the answer to a lot of your questions. Well, you know, what are we looking for? We're looking for, I think, an original legal convention that associates certain sorts of words with certain sorts of meanings. David Lewis's approach hasn't caught on as much as he could, but it seems like he is looking at the basic questions and answering them just about right. So that's all for me.
Okay, John McGinnis.
Well, thank you very much, Dick, for this illuminating paper. I want to raise a question about its implications for judicial review. Assuming you're right, the Constitution has such a minimal meaning that can be discovered by interpretation, and assuming that you're also, I think, you reject probably original methods or original law originalism, I think you are probably too sanguine about those implications in the written version of your paper. So what's the authority of the Supreme Court to impose its will on the other branches if it's not doing interpretation or can otherwise trace its legal decision back to the law of the founding? This seems particularly problematic because many of the founders, Hamilton and others, actually defended judicial review at that time because they said it would be exercised only when legislation was in something, in Hamilton's words, were in irreconcilable variance with the Constitution. You respond that there's probably a little problem with democratic legitimacy of judicial review because the court over time follows the popular will. I don't believe that's empirically right. And I'd refer you to recent work by Larry Baum and Neil Devins showing, I think, empirically that the court follows elite rather than popular views. So I do think that if this paper is right, in other words, if you want to both embrace a minimal view of meaning and a robust theory of judicial review, I think the Supreme Court, you need to defend the Supreme Court, and perhaps it can be defended and needs to be defended, really not through some argument about that it fulfills some democratic function, but sort of the opposite. That's really part of an Aristotelian regime where we have an elite branch that constrains the people for a flourishing society.
So thank you all. I think I can be quite quick, which I think is clearly the appropriate thing to do with so many people in the queue. I think I'm being pushed here by both Larry and by John, at least, to offer a normative defense of a position that is not my central concern to be developing in this paper. But I think my starting point here is really quite Hardian in the sense of HLA Hart. I look at our legal system and I am trying to understand what the rules are. That is what courts what courts do and what it seems to be accepted in the rule of recognition sense that courts ought to do. And I think within the operating rules of recognition of our judicial system as it's operated for quite a long time, it is widely accepted that courts are supposed to interpret the Constitution rather than say that this is an ink blot and there is nothing more to be said, and that courts are supposed to interpret the Constitution in a sense that is not always deferential in a situation in which there is a plausible case to be made that what Congress has done is constitutional. I actually am sympathetic to the idea that the court ought to be more deferential than it is. I so argued in a book that both Larry Solom and Scott Soames commented on, called Legitimacy and the Constitution, that I think was published in 2019. And so I feel a little bit awkward in starting to try to offer a from the ground up defense of as robust a role for judicial review as we have in our system. What I have tried to talk about in past writing, continue to try to argue for today, is the idea that courts ought to be trying to base their decision on reasons of a kind such that even those who disagree could say, I respect the process through which the justices of the Supreme Court arrived at their decisions. But I don't mean to be offering a full-throated from the ground up. If I were designing a legal system, I would want to give judges all this power. I mean to be offering a defense of judicial review as it operates within our constitutional institutions as they have developed over time. The only thing I would say to Chris Green, with much of whose comment I agreed, is that in the paper I actually rehearse in what some people think is tedious detail, the findings of Eric Foner concerning the drafting history of the 14th Amendment. And in light of Foner's findings, I find myself entirely persuaded that there was a great deal of ambiguity about, I shouldn't say ambiguity, I should say vagueness or disagreement about the meaning and implications of the Equal Protection Clause, as well as the privileges or immunities clause. And then just in terms of the way originalists so familiarly think that they can arrive at determinate answers out of what seem to me to be messy linguistic materials. What Chris just asserts blandly as if it were a matter of fact is contrary to what Larry Solom says with respect to protection of women under the Privileges or Immunities Clause, and it's contrary to what Michael McConnell and Scott Soames, both of whom I've seen on this whose faces I've seen on this call, say is the original meaning with respect to race discrimination.
Two very quick things, if I can. One, there was one slide that I skipped over for lack of time, but it comes right on the heels of this. What if
What if there are provisions that don't actually have meanings? Is that entirely possible? The answer is sure. You could have such a thing as communicative failure, either by accident or, as Foner suggests, by design in some instances. That has to be a possibility to acknowledge. That then poses Larry Alexander's question, what then? What if you have a constitutional provision that doesn't actually have a meaning? Okay. Oh, and you've got a provision with no meaning, and you need in the that answers your interpretative question. Then you have adjudicative questions. What do you do in adjudication when you have a constitutional provision that doesn't have any meaning? That's a question of what the default rule is. Larry's question, I think, still stays on the table there. Only other thing I'll say, then I'm going to shut up for the rest of the hour. Other people may disagree. I do not regard constitutional meaning as an historical fact. I think it's a fact. It's a fact of kinds, but it's not an historical fact, precisely because it doesn't lie in the thoughts, the historically real thoughts of concrete people. This is why 15 years ago, Guy Seidman and I wrote an article trying to take historians down a notch, not because we have anything against historians, well, I have things against some historians, but because the enterprise is a legal one. Historians are useful, the same way that economists can be useful in antitrust litigation, but it's still antitrust litigation run by lawyers, done by lawyers. So I think it's what we might call a legal fact. It's a fact of sorts, but I don't think meaning is an historical fact in that sense when you're dealing with the intentions of hypothetical entities, either speakers or listeners. So I would resist that terminology.
Okay, our next troika is Larry Solom, Mike Rappaport, and Will Bode.
So, Dick, I'd like to focus in on the argument that culminates on page 27. This is the part of the paper where basically you're arguing against the possibility of public meaning given the historical circumstances, and you focus in on the 14th Amendment. So first, I think you have overclaimed Foner. I looked through each and every mention of any term that I could think of, like ambiguity, the one you use, vagueness, clarity, various forms of those words. Now, it's absolutely true that Foner says that there were conflicting goals and that important political ideals that motivated the 14th Amendment, Section 1, were the subject of disagreement. But that's different than Foner saying that the communicative content of a particular clause in the Constitution was in fact ambiguous in the sense that in the sense of the word ambiguity that says that there are multiple senses there that are, and they would have to be significantly different from one another. I also went through the book searching for every time he quoted the language of the clauses. And with the possible exception of the privileges or immunities clause, which I agree is tough, I just don't think that the support for your claim is there. So second thing, just a clarification. So Gary and I have different positions. Your sort of characterization of public meaning originalism takes the reasonable person stuff from Gary and then puts it together with some of my stuff. I have explicitly on many occasions over and over again denied that I have a reasonable person theory. There's nothing wrong with using the reasonable person, I think, as a heuristic, but I don't believe that original public meaning is a function of what an objectively reasonable person would ascribe to the Constitution. Okay, so with that in mind, then the central idea here, right, is that there's that public communication faces really serious difficulties whenever we try to convey something beyond what you call minimal meaning. I think that that's very implausible as a general claim, That's because public communication is ubiquitous. There are lots of contexts outside of the Constitution in which we have similar communicative situations, that is multiple stages, drafters, committees, and then bodies that vote. This happens with faculty policies all the time. And yet somehow we're able to understand the New York Times, even though we have very few clues about the communicative intentions of the particular writer, of a particular author, or to take a more analogous case, something that's an NYT opinion page editorial that's not signed. So the account that I offer, which is only available in contractual communication in the Harvard Law Review right now, but is in a paper that is coming out soon, the public meaning thesis, does rely on the idea Gary pointed to, second order communicative intentions, right? And the publicly accessible context of constitutional communication. So you say these ideas wouldn't tell someone who's a member of the public what the Constitution means? Of course not. That's not their role. Their role is to explain how it works, not how you recover public meaning. And the way you recover public meaning is just absolutely banal and ordinary. We do it all the time. Given a second order communicative intention to convey public meaning, then we try to figure out the ordinary meanings of the words, unless they're technical, in which case we look for technical meanings, and we rely on the shared, publicly accessible context of constitutional communication. And so for the 1787 document, that's a bunch of general background facts, but not specific events at the Philadelphia Convention that were secret. The only way to figure out whether this was successful, and it isn't necessarily always successful, I agree with Gary on that, is to do it clause by clause and figure out whether or not we were able to communicate public meaning in the case of a particular clause. And I think for most of the Constitution, it worked. Okay, I'll stop.
Dick, I very much like the paper. And you said in your presentation that you really weren't talking about legal meanings, but I think you and I have a different understanding of legal meanings. And so in an effort to just sort of clarify some of your claims and how broadly they apply, I'm going to sort of ask about legal meanings and, so I see really there's two moves in the paper. One, there's the idea that meanings need to be sort of, basically everyone agrees on them. Sort of Gary pointed that out a little bit. Within the sort of legal meaning world, I think there may be disagreement about this, but I think that we've basically got a 51-49 rule, which says, that there may be evidence on both sides, but just because it's not 100% clear doesn't mean that we don't have a meaning. The other move that you make is to basically say we don't really know who the author is or how to combine the different authors, and we don't have an understanding of the audience. Who they are. But again, I think in the legal world, we've got, a lot of answers to that kind of thing. Once you understand the Constitution as a legal document and it proclaims itself to be one, and you just look at the Constitution, there's lots of legal terms in it, becomes perfectly appropriate to look at it that way. There's a lot of answers to these things. Put differently, we don't have ordinary conversational pragmatic enrichment. We've got legal background enrichment, where our normal sort of background assumptions about how a group enactment, like what's passed by a legislature or a constitutional convention, what its meanings are. So just to give one example of that, you mentioned several times in the paper this sort of Fallon claim that the 14th Amendment should, really what it was a campaign document, or at least that's one way of understanding it. It could mean different things to different people, and I just think, as a matter of meaning, that's just wrong, especially when we take into account the legal context of the Constitution. Statutes and constitutional amendments are assumed in a legal context and not to be campaign documents that have changing meanings depending on who what you're supposed to be looking for is a single meaning, and that comes with the context of a legal enactment. So I guess my sort of overall question really is, to what extent do you think that the legal context addresses these problems that you're raising in the ordinary language? I understand that the paper is not really addressed that, and I guess that's sort of I want to ask you about that here then.
Okay, Will.
Thank you. So I'll be brief. So obviously my favorite part of the paper is the part where you say that if you succeed at proving public meaning originalism is a chimera, then everybody will have to become original law originalists instead. So I probably ought to just wish the project well. But I guess I in light of the concession that there are minimal meanings, I wonder if it's worth more reflection about why that happens and how much more that yields. Because if there are minimal meanings, everybody can agree 2 means 2, then presumably there are also minimal non-meanings. Even if we don't agree on what the Privileges and Immunities Clause does mean, we agree on 5,000 things it doesn't mean. And presumably there could also be minimal meta-meanings, where everybody doesn't agree on what the Privileges and Immunities Clause means, but they agree on what the resources for answering that question would be. And that quickly leads you into something more like what either Mike Rappaport's version of legal meaning or ours. It just seems to me that once there are these easy cases, there might be a lot of other cases that those same methods resolve.
Okay, thanks very much. Terrific, challenging, helpful. I actually think one of the things that starts with what Gary Lawson said in his comment after the prior trio of speakers, and through what Mike Rappaport says and what Will Bode says, is that there is a distinction between what I take to be the claim of original public meaning and claims of original legal meaning. I had thought that what was new and exciting about original public meaning was that it was taking seriously the idea that the Constitution was a public document meant to be understood by ordinary people, not necessarily having any legal background. And the question was going to be, what was the communicative content of the Constitution from its actual drafters rather than some hypothesized entity to ordinary people living in 1787 or 1868 or whatever the relevant year would be. And so again, I don't have any doubt that the law can render determinate what is legally indeterminate. But when, for example, Gary says that in my understanding, the Constitution has an original meaning as a matter of legal fact, but not historical fact. I understand that to be defining an important fault line within originalism. And in this paper, I meant to be raising skeptical questions for those who are on one side of that divide. Now, of the people who've asked questions, I take it that the one who is clearly on that side of the divide is Larry Solom. And I just disagree with the reading of phoner, but I don't think it's worth everybody's time to go into that. What I think may be worth everybody's time is Larry wants to say, if I understand him correctly, that there's no particular mystery about applying what I have called the model of conversational interpretation, or the methodological assumption of public meaning originalism to documents that didn't have clear authors and that had radically diverse audiences. And he said there's no mystery about it. It's banal and ordinary, and it happens all the time. But then I just want to come back to the question that I framed, and here I want to enlist Gary Lawson on my side once again. The question, what in the world makes it true? What in the world makes it true? And at this point, there is some natural inclination to bring in the idea of evidence. So Mike Rappaport says, well, in the law, if it's 51-49, we say 51 wins. But 51% of what? I mean, what in the world are we actually trying to prove? Is it what most people thought? Well, I take it most public meaning originalists say, no, that's too much like a public opinion poll. Where linguistic fact, which is what we're about, is what the actual meaning was, even if a whole lot of people misunderstood it. Well, what in the world makes it true that this is the correct interpretation? Larry's written in other places, meanings are either true or false. I'm sorry, interpretations are either true or false. It's just a matter of fact. Well, what is it in the world that makes them true? We can say the evidence is mostly in favor of interpretation A over interpretation B, but we can't say that unless we know what it would be in the world that would make interpretation A true and interpretation B not true. If we don't know that, then how can we tell what counts as evidence that amounts to 51% on one side and 49% on the other side? So that's the question I want to keep coming back to. What in the world is it that makes interpretations true if they are true? And it could be, they could be true as a matter of law, and then we'd be into an argument about law, but I don't take it that that's what I'm mostly concerned about, which in this paper, which is I take to be public meaning originalism, trying to say, among other people, among other things, to those in the audience who may be original law originalists. No, I think you're wrong. I think we should be concerned with original public meaning rather than original legal meaning.
So our next trio is Evan Bernick, Scott Soames, and John McKyle.
So I really like this paper. I heard you deliver it at the NYU symposium, and I really like how this version in particular makes very specific your core ontological claim that original public meaning just does not exist in most live constitutional controversies. But I'm still hung up, as I was then, on just why you think ontology carries so much normative weight. And I would like to see you spell out in more detail what weight you think it carries and whether it also carries weight with respect to things like constitutional principles or moral values, which may have ontological issues but are objects of interpretation under competing constitutional theories. I mean, fundamentally, I just don't think it's at all obvious that good constitutional interpretation requires good ontology. I can think of no better example than individual intentions. There's reason to doubt that individual intentions exist in the same way of, in the sense of being reducible to mental states that are themselves reducible to neural states, but it would be crazy to ditch our use of individual intentions in wide areas of law if it turned out to be true that that was the case. I mean, there are compelling normative reasons to act as if things like intentions, centers of gravity, voices, and other potentially non-existent in some strong physicalist sense thing are true. And what's particularly striking about the weight you assign to ontology without really explaining its normative implications is that you You cite Ryan Dorfler, who confronts this head on in his paper on congressional intention. You cite him for the proposition that it will rarely be the case that we have we intentions that could reasonably be attributed to Congress in proposing a constitutional amendment. But Dorfler is quite explicit that he doesn't think that the lack of we intentions as a matter of ontological fact should lead us to conclude that we shouldn't act as if such intentions exist. And he argues that we should actually do that. And we should adopt something like public meaning originalism with respect to statutes. So at the end of the day, as much as I enjoyed this, I think that there is there's a missing piece that leads you from the claim that the object of public meaning originalism doesn't really exist to the normative conclusion that we shouldn't adopt it, and we should instead adopt some other theory that might have similar ontological problems, but also may be useful and normatively defensible despite that.
Okay, thank you. Boy, there's a lot here. There's a lot of good comments that I agree with the spirit of. I want to make a very focused point. I don't want to take a long time because we've been talking a while about this extension of the conversational model that Richard is skeptical about. And I just want to say a word about what the conversational model is. And if we understand that word, we will have, I hope, a better idea of how to extend it to plural speech, that is, the speech of plural agents like a Congress or a committee or something of that kind. And in the legal case, yes, legal meanings are going to be quite significant. Okay, the conversational model. When I'm talking to you now, or others would be speaking, I'm using language which has linguistic meaning in English, which we all understand. And my remarks, when I choose something to say, I have some proposition P in my mind. And when I choose something to say, I, as an individual speaker, want to convey that to you. Now, if I assertively utter a sentence, then, and I'm trying to assert some content, I hope it's the content P that's in my mind. And what is it to assert something? It's in effect to give one's personal assurance or guarantee that P is true. And because that personal assurance or guarantee can be significant for the person that I'm talking to, there are certain obligations that come with assertion that are like the obligations that come with promising. If I promise to do so and so, then I put myself under an obligation to perform a certain act. And if I vouch for or certify the truth of a given content, that can be important for those I'm speaking to. That can lead them to take acts. And if I mess up, if I end up thinking I'm asserting something, but assert something different, then I'm responsible for that. So what I try to do is this. I've got a P in my mind, and I want to choose a text, a sentence, that has this characteristic, that if you have been an attentive listener and you have, you're cognizant of everything going on in the conversation that I'm aware of, that you will arrive at that very same proposition. That would be communicative success. But sometimes I mess up. Sometimes I use the wrong name. Sometimes I use the wrong word. Sometimes I point in the wrong direction. And so what a reasonable, attentive hearer of my remark would conclude is Q, not P. Now, suppose Q leads this person astray and somebody asks, well, why in the world did you do this? And you say, well, because Scott told me the Q. Scott asserted the Q. And the fact is, I did, even though that isn't what I intended to assert. Well, yes, I did really have two intentions. I had the intention to assert P, but I also had the intention to assert what a reasonable and attentive listener would be most justified in taking me to have asserted. And when those two things come apart, the thing I really asserted is Q, not P, even in the individual case. Now we just move to a plural case. Suppose we have a legislative body or lawmaking body. It's made up of 10 people, and there's a question before them, and there's a certain text, and with that text, the 10 individuals have 10 private Ps. Some of them could be the same, or some could differ from others. Suppose that body votes 6 votes in favor. Then some content associated with the text becomes law. Now, it could very well be that you take 6 supporters and you take 6 private Ps, and some of them, in extreme cases, it could even be all of them, but some of them are at variance with the Q that is rationally the proposition most justifiably derived by any audience who knows not the private states of mind or the private thoughts or the private conversations of the 6 supporters, but who knows the full public context. What's public is the drafting, the amendments, the rejections of some amendments, and so on, and then the support. And what gets asserted is that public content. Now, when you have something like the 14th Amendment, which has got all sorts of fraught issues involved, and it's fairly complex, it can easily happen that on one or another complex subject, there's not a majority of private Ps that agree with one another. But that's not important. If some historian looks at their diaries, looks at their private letters, looks at their correspondence with other people, what have you, and finds that there was quite a bit of difference, that's not something that should worry the constitutional interpreter. The constitutional interpreter should say, what would a rational audience who was aware of all the ordinary and the legal meanings involved and all of the public steps involved in the formulation of the legislation most rationally conclude? And that, it seems to me, is the legal content. Even if there was lots of private dispute about it, because we treat the author as a rational agent who has taken certain steps and used certain language, and the content we ascribe to the result is this idealized content. There may be no member of the public who understands all of it. There may be no member of even the legislature who understands all of it. It's an idealized content, but it's got to be something that is derivable from public sources. And we could put the whole string together and come up with the best result. Okay, that's the way I view it. And I'm thinking that if you think about the Speech Act model this way, it's a straightforward assumption. It's a straightforward generalization of the ordinary case, because the 6 supporters have the private Ps, but they also have a unified intention to commit themselves to the Q that is most defensible as a derivation from the public context. And it seems to me that might be able to meet some of your worries.
Thank you all. It's been extraordinarily helpful. With respect to Scott Soames, I don't think I disagree with anything you say, but I think I may disagree with what you take to be the implication and I don't take to be the implication. I take everything you say to support the idea that constitutional provisions have what I call the minimal meaning. And I take it that that minimal meaning would not resolve disputed questions in the context of the 14th Amendment. I just point again to disagreements among those of you in this room. Chris Green on one side, Michael McConnell taking a different view, Larry Solom taking a different view about the meaning of the of the privileges or immunities clause in its application to women who want to practice law. Yes, there is minimal meaning. Language works to that extent. It just doesn't work with the same determinacy that it does in the private conversational context, when it works well in the private conversational context, such that we get to a determinate meaning that would resolve disputes about how best to apply the 14th Amendment without an infusion of either legal or normative content. With respect to Evan Bernick's comment, there's a way in which I'm sympathetic, there's a way in which I'm not. I hope this isn't a caricaturish way to put the point. When I say, and Gary Lawson picks this out as what he takes to be one of the principal points that I'm making in the paper, when somebody makes a claim about historical meaning, we should be asking, what in the world makes this true? And then I take it that Evan wants to say, well, nothing, but it's still a useful fiction for us to believe that there is such thing as an original determinate public meaning, even though there is nothing in the world that makes it the case that there was that original public meaning. And at this point, I am inclined to think here, I think back to Larry Alexander asking his normative question, by what right do we think that the Supreme Court does certain things? I would say not just by making up some fictional claim about a fictional original public meaning, when the person making the claim can't point to anything in the world that makes it true that that actually was the original public meaning in the determinate sense for which the claim is being made, as opposed to the more minimal sense in which I agree with Scott Soames that constitutional provisions do have original meanings. And so thank you again, all of you, thank you.